Yes.
Lordship, I kindly to mention upon notice, Lordship, it's item 34 in Lordship list today, company matter new Lordship. If Lordship, this matter didn't call today, Lordship, I'm praying for some precedence next Friday, Lordship.
Why? What is the ground?
Lordship, the agency, the disbursal is not for the petitioning creditor, Lordship. Since the pendency of this application, disbursal of the amount is not been taking place.
No upgradation. Sorry. Other matters are also equally urgent. Yes, call on the list.
May I come to mention on that?
Yes, sir.
I just mentioned the matter.
Could you just said matter?
No, matter. I'm going to draw your attention.
This is single bench. My single bench.
Division bench. This is
Division bench. When I sit in the division bench.
order.
No, Mr. Ghosh. When I sit in the division bench. Mention when I sit in the division.
May I mention item number 7, 8, and 9 in original site? These matters, this Khemka matters, revival application, these are all 20th of December. This is the last order.
20th of December. These were supposed to come on 20th of December.
Last order.
Oh. হ্যাঁ প্রদ্যুৎ এটা আজকে এসছে 20th of December রিটার্নেবল ডেট ছিল
7, 8, and 9 today's list.
20th December তো ছিল anyway we'll take up on 20th December 20th December then 7, 8, 9 20th December fix ছিল আজকে কল হবে yes call on list
item number 1 and 2.
yes
We have already submitted our written notes of argument.
Oh, that for that one.
For him.
You are for the petition.
My lord, item 1, my lord, I am the petitioner. Item 2, my lord, I am the respondent.
Haldia Development Authority.
My lord, item 2, I am the respondent. My lord, what I have done is I have filed, my lord, 2 separate written notes.
Well, I have filed one because if I succeed in that event.
No difficulty. Very well. The written notes of arguments আজকে না একটু তাড়াতাড়ি পাঠিয়ে দিন বেরিয়ে যাবো 12টা উঠে যাবো the written notes of arguments filed on behalf of the Haldia Development Authority today be kept on record. Pushap, hearing is concluded and judgment is reserved in the matter.
Grateful, my lord.
Thank you. 10:30 টা কল করুন
Item number 4, matter.
My lord, in item number 4, my lord, I am appearing on behalf of the alleged contemners, my lord. The contemners are present in the court, my lord.
There's a personal appearance direction.
Yes, my lord. There was a personal appearance direction.
Arrest.
No police. But my lord, they are present in court, my lord. We have, my lord.
Why were they absent on the last day?
My lord, I prepared an affidavit, my lord, for your lordship's consideration, my lord, for both the contemners to explain their conduct, my lord.
What is the explanation?
My lord, yes, my lord. These are the 2 affidavits, my lord.
Have you given copies to the other side?
No.
Give copies. What is the explanation?
Yes, my lord.
Repeated orders, not complied, repeated orders.
My lord, I'll just indicate, my lord. My lord, initially, my lord, when the receivers came, my lord, it was explained to them, my lord, that the Ranchi municipal authorities are ready and willing to repay the money, my lord. They are ready. They have come to court with the demand drafts of the 4 crore, my lord. My lord, in my affidavit, I have indicated since 1st of July 2020, the money was ready.
So why wasn't it paid when they go?
My lord, in my affidavit, I have annexed letters.
You could have saved this embarrassment.
My lord, we have annexed letters, my lord, by which we had approached RAI. We had approached RAI in September 2020 and October 2020, requesting them for a certified copy of the order, indicating that the money is ready. Kindly collect the money. These letters we had issued, my lord, and these letters are a part of my affidavit. And so far as the rule is concerned, my lord, when the contempt rule was issued and the warrant was issued, my lord, the contender number 1 was the additional chief election officer. My lord, I'm led by Mr. Thakkar, my lord. May he?
Yes, Mr. Thakkar, you could have just explained to counsel that this is the reason you are not coming. On the last occasion, when the rule was issued, you could have explained. He was the chief election officer or something like that. So you could have just come to court and explained. There was no explanation. That's why we are compelled to. We don't generally issue rules unnecessarily to public officials.
Yes, I know, my lord.
It's against our norms.
No, my lord,
But if you choose to violate and not come and no explanation.
Intention to violate, but there was a lapse on our part, my lord, for which we tender.
It is submitted that you are ready with the bank
Both are
draft.
present.
Yes, we have seen that. So if you are ready with the bank draft, then hand over.
I am.
You go through the bank draft and go through this affidavit also. We'll keep it on next Friday. We'll dispense with personal appearance for the time being.
The warrant.
Warrant of arrest will discharge that.
Time.
Yes. Both the alleged contemners are present in court today. Full stop. Affidavits of show cause are filed on behalf of the alleged contemners individually. Full stop. The explanation furnished is that the alleged contemners had offered the uh, ordered amount on several occasions and due to unforeseen circumstances, could not attend the court on the last occasion. Full stop. Next para. Being prima facie satisfied with the explanation, the personal appearance of the alleged contemners is dispensed with for the present. Full stop. The warrant of arrest issued earlier is discharged. Full stop. Next para. Since the alleged contemners tendered the demand drafts, let those be handed over to the learned advocate for the petitioner. Full stop. The petitioner shall ascertain whether the same is sufficient compliance of the order of this court. Full stop. For such purpose, let the matter be listed next on December 20, 2024. 2024.
The original demand drafts are to be handed over, my lords. Yeah.
Demand drafts are to be handed over.
Original demand drafts.
Original demand drafts, yes.
So your lordship may record that I've handed over.
Very well. আরেকটা line add করে দাও. After the above order is passed, the demand drafts. How many demand drafts, Mr. Thakkar? One.
There are five.
Five. Demand drafts, the particulars of which are given below, are handed over to learned counsel for the petitioner. Just give the particulars.
Copies to your lordship's officer, my lord. It can
Very well. Copies, photocopies
The
of the
demand
state
drafts are
demand drafts.
dated 11 December 2024.
So no difficulty.
No, man, just for record.
Photocopies of the demand drafts handed over in court today.
Yes.
Be kept on record. এইগুলো দেখে
And my
দেখে
lord, we are the
particulars
petitioner in the
গুলো
EP, my lord. We are not petitioners, yes, my lord. We are in EP.
petitioners in the main read.
No, I mean section 9 application, my lord.
Very well. Petitioners যেখানে যেখানে বলেছি ওখানে it will be qualified by petitioners in the section 9 application. Handed over to petitioners যেখানে যেখানে বলেছি in the section 9 application.
is to discharge the warrant, my lord.
এই particulars গুলো as given below বললাম ওই particulars গুলো এখানে ওই নামটা আর ডিমান্ড ড্রাফট নাম্বারটা আর কার উপর ড্র করা হয়েছে ইন্ডিয়ান ব্যাংক drawn on Indian Bank in the name of such and such for an amount of এত আর এটা এই চারটি জিনিস অ্যামাউন্ট নাম্বার ড্রয়ি আর ব্যাংক আমি ঠিক নেই সব কটাতেই তাই
Please to
না 10:30 আর তো বলছি না আমি আর ডিসচার্জ ওয়ারেন্ট অফ অ্যারেস্ট ডিসচার্জ করে দিয়েছি personal appearance dispensed with warrant of arrest discharge.
There's just one more thing.
Yes.
I've handed over the demand drafts. They are, my lord, required to take steps to transfer the ownership of the vehicles to me. So that they should ascertain.
Mr. Thakkar,
Because that
will-
is there in the original order.
Let them ascertain and come back whether the demand drafts in order. Please remind us on the next occasion. We'll pass necessary.
But my learned friend should take instructions
Yes,
about
man.
the
We'll do
transfer.
that, man.
Definitely.
Yes,
If you have to do something, you have to do your part.
Yes, sir. We'll do
Yes,
that.
sir.
Thank you.
Deeply obliged.
My lord, they will encash the remand drafts in the meantime.
We have not said anything on that.
After next,
Don't do that.
No.
Don't encourage.
after next Friday, my lord, after
Next
the
after. Next Saturday.
after order is passed, then only.
Beautiful.
Right.
my lord.
Much
When
obliged.
I file the wakalatnamas, the department will not accept because it's with a short cost title.
Very well. The leave is granted to
File.
file the wakalatnamas with short cost title in the department.
Yes. Only endorse.
লিভটা দিয়ে দেবেন ডিপার্টমেন্টে ফাইল করুন
Grateful.
থ্যাংক ইউ ইয়েস
Happy for the petitioner, my lord.
Payment has
I'm
Yes.
just seeking a short passover, my lord, as per the instruction from my senior, my lord. He's engaged in some other courts. We'll be
why
here.
short they are here second matter of the day what is this Mr.
My learned,
You said you have complied
I said I have complied with Lordship practices for Lordship's last order. My lord, it was pointed out by the petitioner that possibly certain amount has not been paid. So I assured your Lordship that I will look into the
Yes.
matter and sit with him, my lord. If that amount has not already been paid. But I have looked into it, that the entire amount has been paid. I can demonstrate it from the affidavit which I have filed. But my learned friend is not here, but if your Lordship so desires, I can
we'll
demonstrate.
keep it next Friday then no use passing it over
crores 88 lakhs 23,000.
that has been paid
Yes.
Part payment is still left, your lordship, for making the payment.
That is the dispute.
As per your lordship's order, a part to be payment as.
No, as per my order, you submitted that. They say that the entire amount has been paid. You have to satisfy us.
Amount bolbe not.
Alampoli was supposed to get 3 crore 45 lakhs, your lordship, but actually.
Are you ready with the matter? Then I'll hear it right now.
No, your lordship.
An adjournment is sought on behalf of the petitioner, Footstep Learned Senior Counsel appearing for the alleged contemners submits that the entire amount to the tune of rupees 2 crore 83 lakh.
Just give me 1 second. 2 crores 88 lakhs 32,000.
2 crore 88 lakh 32,000 has been paid.
57,000 1900 as
What are you saying?
Interest subsidy.
This the principal amount along with interest.
Interest subsidy.
Subsequent lordship.
That document, my lord. It is 3 crores 35 lakhs 31,747. I submitted on the last occasion.
তাহলে এটা বলে দেন।
Total.
3 crore
35 lakhs
লিখে নাও
31,747. The three
has been paid, which is disputed by learned counsel for the petitioner, Footstep, to ascertain the veracity of the contentions of the parties, comma, let the matter stand over till December 20, 2024. Please come ready on that, because they say that the 3 crore something has been paid.
Interest part is left and your lordship.
They say it has been paid. They say it has been.
Subsidy, your lordship. As per your last order, as
We'll
per
consider that.
your order.
There cannot be any peaceful. I told you whether you were ready in the matter. You said no. We have kept it on next Friday. Please come back on next Friday. There's a limit to everything. Either you submit or you don't. Next matter, please. Yes. Yes, Mr. Pal.
I'm with the petition.
Mr. HON'BLE is for the alleged
Contempt, right?
Lordship affidavit, Lordship. I have sought.
This is the
Reply.
affidavit filed by the alleged contempt, lordship.
Wait,
Lordship,
let the
I have
file be
sought
given first. Google now affidavit.
This is the affidavit of compliance, my lord.
Lordship, this is a reply, Lordship.
A reply to affidavit of compliance. The-
Copy.
Mr. Pal, what was the direction
Lordship, I
order?
have served. He's saying that he has not got, but
Have you got a copy of this?
Lordship, these are
Service. It has been served. Not with you.
Not briefed in the matter, my lord. Mr. HON'BLE is in the matter. He's on his legs in courtroom number 35.
Yes, Mr. Paul, what can be done?
as per your Lordship.
What was the direction? Let us see the direction.
Lordship. Page 21, my contempt petition, Lordship.
Yes. To decide on the representation, opportunity of hearing?
Accordance with law.
Yes. In accordance with law, whether it's lawful or not, that will be decided in a further challenge. They have decided.
Lordship, they are turn Lordship, if their affidavit, Lordship, they have not disclosed the document, but earlier they have disclosed the document.
Achha. They say they have given a hearing to you and they have decided.
Yes, lordship.
Lordship,
You deny which
two
portion?
parts, Lordship. First part, Lordship, they have stated that they have given hearing, and that is after the expiry of the date fixed by your Lordship. That is contempt is continuing, Lordship. Number one, and there no explanation as why they have caused that delay. Only they prayed for mercy, nothing else, Lordship. And Lordship, second, Lordship, we have submitted documents. They have admitted certain documents we have submitted before at the time of hearing, and Lordship, they have spot inspected. As per their averment, they got some information from the spot inspection, but thereafter no hearing.
Have you got a copy of that their order? They were to dispose of the representation.
Lordship,
They have not disposed of.
Lordship, they have disposed of only.
Where is that decision taken by them? Have you
No,
annexed that?
Lordship. They have not annexed it.
Yes, where is the decision?
Paragraph 11, lordship, it has been stated. Kindly comes to my affidavit, lordship.
Documents ta kothay?
I state that after spot verification of the property on 28th September, there was a gap due to Durga Puja celebration, and after resuming office, I have done my calculation for the assessment of the said property. So,
Where is that communication? You have said you have communicated to them on 21st of November 2024. That's the most vital document. You have to show that we have communicated.
Lordship, this is the order.
Communication.
They have not annexed it.
But
In their affidavit,
There is-
they should annex this sort of things.
So they have assist, Mr. Pal.
Lordship, but Lordship, the passed the order that after hearing, Lord, I have submitted so many documents.
You have been given hearing.
Hearing given. During hearing, I have submitted documents, Lordship, and they have spot inspected and they have admitted that in the spot inspected they got some documents, some information and documents. After
Mr. Pal,
that,
that entails a new challenge.
no, Lordship order is that,
This is
Lordship.
not contempt. You cannot decide in contempt.
No,
We
Lordship,
decided that they have to give you a hearing
Lordship, is this an order?
and to decide if it's an order, if
It
it's
is
not a
the
proper
order,
order.
Lordship. That is why my submission is that they have not complied with. This is not the order.
Contempt, Mr. Pal, we cannot decide whether it's in accordance with law. We directed them to dispose of the petition upon giving a hearing, which they have done. And they have additionally spot verified. So there is no bar to spot verify.
Lordship, hearing means following the natural justice. So after spot inspection, they got some information which they have not served us.
No, that's
So these order, Lordship, these order cannot be said that complied with the order, Lordship, because this is not an order, Lordship. Because after hearing, there should be a reason why, how they come to this conclusion.
These are not judgments of court, Mr. Pal. These are registry. These are registered assurance.
Only sleep, Lordship. That is.
There is no
assessment
compulsion
slip.
under law to give reasons.
No, Lordship, hearing, when hearing was, Lordship ordered for hearing, and I
They
have
were to give
submitted
you
some
hearing.
documents.
Yes.
I have so they have to explain how they come to this assessment.
No, then Mr. Pal, you
What
are
is the
entitled
basis
to
of the
challenge under the law. You are entitled to challenge.
But
not law.
your Lordship order is there upon giving hearing. That means they have to pass. They have to
They
give.
gave you a hearing, you produce documents.
But reason why? Why is the
Reason
is
is
the order?
not, reason is not required.
It is the is it the order?
Registered orders, assessments do not require a reason under law.
Lordship, how they have access? Because I have submitted so many laws, Lordship. Because they cannot do this. After completion of 5 years, they
That's
cannot.
a
do
wrong
this.
assessment. You are entitled to challenge under the.
That is true, but this is not an order. First thing, Lordship. If it's a wrong assessment, I have to challenge. But this is not the order. This is not compliance, Lordship. My submission is that because after hearing,
We said that they have to decide on the representation given. They have
Lordship,
assessed. After giving-
representation. What is the representation? Can you see? What is the representation? Lordship,
Page
Lordship,
of the of your opposition.
Lordship. I have annexed it. Lordship, page 87 in the writ petition, Lordship.
Writ petition টা দাও।
Has your Lordship got it?
Yes.
We would therefore request to kindly consider representation and complete the registration of the aforesaid document by accepting the set forth valuation mentioned in the deed. Why they have not accepted my, that has to
No,
be given.
considering your representation does not mean allowing the contention in the representation.
Lordship, but they have
You said
given
that
reason
no,
why my contention is
Mr.
not
Pal,
proper.
you said that they have to accept the set forth value mentioned in the
They may
deed of
reject.
conveyance.
I don't mind, they may reject. Where is the
They have
rejection?
assessed. That's the rejection.
Lordship, where is the reason, Lordship? Why they have reject? Because
Pal,
after
this
hearing, Lordship, if there is no hearing,
Contempt
they can.
jurisdiction is very limited.
they can. But after hearing, they have to give a reason.
No.
After hearing, Lordship, they have to give. Lordship, I have submitted a deed of
You
the.
can assess, challenge the assessment.
Lordship, I can challenge. Lordship, I don't mind. But whether it is a compliance, Lordship, that is my question, Lordship.
No, Mr. Pal, this is
Lordship.
compliance. Learned counsel. Learned counsel. The affidavit of compliance filed by the alleged contemptor and the affidavit in opposition filed by the petitioner be kept on record. Full stop. Next para. Learned counsel for the petitioner's contents that although a fresh assessment has been made on November 21, 2024, no reasoned order has been passed on the representation by the petitioner. Full stop. Next para. Learned counsel places reliance on the said representation dated March 18, 2024, annexed at page 87 of the writ petition, where the petitioners stated that the alleged contemptor was requested to consider the representation of the petitioners and complete the registration of the document by accepting the set forth value mentioned in the deed of conveyance dated 29th January 2007 and hand over the same to the petitioners immediately. So it is submitted that the fresh assessment does not reflect the position of law as contended by the petitioners during the hearing and stroke or the several documents which were also produced by the petitioners. Whose sub next para, upon hearing learned counsel, comma, I find that in the order under contempt, comma, the alleged contemptor was directed to decide on the representation given by the petitioners dated March 18, 2024, in accordance with law, upon giving an opportunity of hearing to the petitioners as expeditiously as possible, comma, positively within 3 weeks from the date of communication of the order to the alleged contemptor. Full sub next para. Although admittedly the order has not been complied with in time, comma, I find from the submission of parties that a hearing was given to the petitioners, comma, including an opportunity to furnish documents relied on by the petitioners. Full stop next para. However, comma, at the same time, comma, it has to be kept in mind that assessment of stamp duty by the registrar is not at par with judgments of courts and does not require detailed reasoning. Full stop next para. The absence of reasons cannot vitiate the order per se. Full stop. However, comma, the petitioners in any event always have the liberty in law to challenge the fresh assessment if they are so entitled in accordance with law. Full stop. Next para. Be that as it may, comma, it is beyond the jurisdiction of the contempt court to assess whether the fresh assessment made by the alleged contemptor is actually in accordance with law and stroke or whether the petitioner's contention before the registrar stroke alleged contemptor were also in consonance with law. Whose sub next para. Such appreciation on law and fact is entirely outside the domain of contempt. Full stop. I find that in fact, comma, a hearing was given to the petitioners and a fresh assessment has been made thereafter. Full stop. As such, comma, I am not inclined to stretch the contempt jurisdiction so far as to enter into an assessment on law as to whether the assessment is correct vis-a-vis the arguments of the petitioners. Full stop. Next para. Accordingly, uh, in the opinion of the court, comma, no penal measure for contempt need be taken. Full stop. Since the petitioners have sought has have since the alleged contemptor has tendered apology for the delay in occasioning in complying with the order of this court, comma, the same is accepted. Full stop. Accordingly, CC number 56 of 2024 is disposed of. Full stop. However, comma, the petitioners will be at liberty to challenge the fresh assessment by the alleged contemptor dated November 21, 2024 in accordance with law. In accordance with law. No order is to
Since Lordship, I have also argued that
yes.
that here spot inspection, they got some information. And after spot inspection, no hearing was given. Lordship, kindly note down this.
Mr. Pal, that is a part of your argument.
And Lordship, kindly extend the time, Lordship, because 21/11/2024 notice, they have stated that within 1 month I have to done this registration process. Lordship, page 22.
No, why should I extend that in contempt?
Because today we are on.
You are free to do that, irrespective of the contempt. Contempt does not mitigate anything.
No, Lordship, they have
You have a
given
right
within
in law.
1 month, otherwise that will be cancelled. Lordship, page 22, kindly,
But
Lordship,
in
my
contempt, you cannot do that. Why should I do that? If you have not challenged it, it stands cancelled then.
Lordship.
And Mr. Pal, in any event, Section 14 principle is applicable to Limitation Act.
That is
Yes.
Deeply obliged, my lord.
Item number 6.
Yes.
Thank you. No. The compliance affidavit has not been filed, I think not shared with us.
For the statement, I am seeking just under 2 weeks time.
My lord, kindly issue rule, my
Kindly,
lord.
my lord.
Kindly
Kindly
issue
2
rule.
weeks time, my lord, so that
It's time. It's time.
When was it last directly? Let's see.
Kindly take the last order dated 22nd November
Yes,
2024. Several adjournments had been taken. State has not preferred any appeal against this order. As has been recorded.
No, state submitted that an appeal has been taken out against the parent order.
No. WBIDC. This contempt is against the state officials.
Now, my lord, the state is, my lord, in this week, next week, one Monday or Tuesday, we will file our appeal.
And in
No, no, we
contemplation
should-
of appeal, my lord, rule has to be issued.
When was the order passed?
Order was passed on, my lord, the main petition order.
Main the
8th April.
8th
8th April.
So Bushmalik, there are at least 1, 2, 3, 4, 5 orders in
Yes,
between.
yes.
5 orders in the main.
Yes, several
Have you preferred any appeal?
No.
Then we will issue a rule.
No, my lord, next week, my lord, I have specific instruction, my lord, next
Your
week.
instruction, keep your instruction with you.
Kindly, as a last chance, my lord.
Who should be issued a rule? of Principal Secretary.
As a last chance, my lord.
No
kindly.
last chance, sorry.
As a last chance, my lord, kindly, my lord.
Learned counsel appearing for the alleged contemner submits that as a last chance to the alleged contemner to comply with the order, comma, a fortnight's time may be granted. Push up next para. Learned senior counsel appearing for the petitioner points out that till date no appeal against the parent order dated April 8, 2024 has been preferred by the state, and as such, comma, the alleged contemner is palpably in contempt. Push up next para. I find from the records that at least on 5 occasions, comma, the contempt application was taken up. Full stop. Since the state has not yet found time to prefer any appeal against the parent order, comma, nor has the alleged contemner complied with the same, comma, this is a fit case where a rule should be issued to ensure that the alleged contemner is personally present in court and explains her conduct. Push up next para. Since this court is of the opinion that there has prima facie been willful and deliberate violation of the order dated April 8, 2024 by not complying with the same, comma, a rule do issue calling upon the alleged contemner to show cause as to why penal measures as paid for in the contempt application shall not be taken against the alleged contemner. Full stop. The rule is made returnable on January 10, 2024 at 10:30 a.m. 2025, sir. Yes. Thank you.
It is number 10, order matter after
Yes.
INC versus local district.
Yes. 789 to হবে না 789 were fixed on 20th, Mr. Bose. It was mentioned in the morning. It was supposed to come on 20th. Someone mentioned and said it is right. So we cannot take up this matter. And there was a previous direction for taking up on 20th.
I didn't know. There was a noting that
I also did not remember.
last chance to the official liquidator. So
Last chance, but it was postponed till 20th by the last one. That last chance will come on 20th. 10. Oh, this is 10. Yes, sorry, Mr. Mitro. Yes.
Well, this is my application for deletion of the name of the company from
Mr. Mitro, I'll be sitting till 12 today. I have some pressing work for which I have to leave. So till 12, I'll be hearing the arguments.
As far as I'm concerned, I will not take very long.
Very.
Yeah, affidavits may hand over. The opposition is there, replies.
একটা order record করুন affidavits in opposition ওখানে বসে দিই affidavits in opposition and reply filed to be kept on record তারপর বাকিটা যা দেবো অন্য কেউ হলে তাকে বলে দিও যে এটা অ্যাড করে yes miss
My lord, if your lordship sees the prayer, my lord,
affidavits গুলো দিয়ে দিও yes
the prayer in the master summons that local healthcare system, that is respondent number 1, be deleted as party respondent from EC so and stay off all further proceeding.
Yes.
But the reason why this application has been made is because the award, my lord, permits me to do so. That's why we have come before your lordship. My lord, kindly take the award that is in volume 10.
You are appearing for local?
Yes, I am appearing for the company.
Volume 10.
Volume. Second volume. volume 2, second volume. My lord, this particular application has been made in 2 volumes.
Yes.
Volume 1, this is a long, very long award. So my lord,
ঠিক ভলিউম
it is-
2টা দিয়েছে তো অ্যাপ্লিকেশনের ভলিউম 2 এটা
volume 1 and volume 2. I request your lordship to come to page 184 in the second volume.
Yes.
The part of the award, paragraph 379. I shall
Yes.
just explain to your lordship why we are moving the application. Paragraph 379, this is a part of the main award.
Yes.
The question also arises, what relief would the claimant be entitled to in the event the respondents fail to hand over the actual control of the company with all its assets. My lord, kindly note these words, with all its assets provided for and contemplated by the SPA on or before 30th September 2024. It is noted that the claimant has not provided for such a scenario, but rather has sought and calculated damages on the basis that it would not receive the control of the company. The tribunal determines the claimant is thereafter entitled, in addition to the primary damages, to the damages assessed by the tribunal in paragraph 382 below for permanent loss of actual control of the company. Then para 380 is very important. However, in the event the respondent at any time prior to 30th September 2024 offer, my lord, kindly note these words, offer to give the claimant the actual control of the company without all or some of the assets provided for and or contemplated by the SPA without prejudice to the other paragraph 379 above, the claimant may forthwith elect. My lord, kindly note this, that this paragraph 380 contemplates an offer by the respondents and my lord, election by the my lord, the claimant. Then he will have to elect to receive actual control of the company, notwithstanding diminution of its assets, because my lord, all the assets are not being given. And B, recover from the respondent number 2 to 6 additional damages amounting to USD 80.7 million for the permanent loss of actual control. Now, my lord, kindly come to 381. Under scenario A above, the claimant may elect to receive the primary damage and actual control of the company, notwithstanding a diminution of its assets. In scenario 2 above, the claimant would recover the primary damages and the additional damages assessed below, but it would not have the actual control of the company. So the alternative has been given. Either you receive, the claimant will have to elect to receive the primary damage and the actual control of the company without all or some of the assets, or he will have to elect for not taking the company but taking the additional damage. This is. Now, my lord, kindly come to the dispositive portion of the award. Lordship kindly comes to page 198, the conclusion, the award. Paragraph 414. This is the actual award. In the event the respondent at any time prior to 30th September 2024 offered to give the claimant actual control of the company without all or some of the assets provided for and or contemplated by the SPA, the claimant may forthwith elect either to receive the actual control of the company, notwithstanding diminution of its assets, or alternative, to recover additional damages amounting to USA 80.7 million. Then on 415, if the claimant does not secure, kindly see the change in language. There is no question of any offer or election. If the claimant does not secure actual control of the company, together with all assets provided for and or contemplated by the SPA on or before 30th September 2024, and paragraph 414 does not take effect, this is similar to the earlier paragraph, the claimant shall be entitled to additional damages amounting to. So I am saying, my lord, that before 30th September the claimant did not secure actual control of the company. And since he did not do so, then, my lord, the only alternative for them that they will receive, my lord, 80.7 million. So my respectful submission is this, that after 30th September,
that 80.7 would be received from the other respondents, not one.
No.
So therefore, you say one should be expunged.
This is my short submission. Well, kindly come to the page 204 in this connection. This is the dispositive part. At page 201, it starts.
Yes.
Title is dispositive part.
Right.
It says that having considered all the evidence and submission placed before the tribunal, and for the reasons set out above, the tribunal hereby declares, determines, and awards. Page 201, dispositive part, 423.
Yes.
And then 423, ABC like that. Kindly come to page 204. The portion I'm interested in. Your Lordship, again, my lord, the same thing. First is I is, your Lordship says, I. The primary damages, my lord, against these parties. Then J, in the event local healthcare system private limited, Dr. Syed Sawad Azmin, Richa, etc., etc., at the time prior to 30th September 2024, offered to give UpHealth Holding, that's the claimant, actual control of healthcare system private limited, the company.
So if
without
either you don't offer that actual control or they don't take actual control, then no liability of the compensation or damages is cast on one. Whatever then has to be paid by two onwards. So therefore, you say one should not be there.
But this I am, because well, the reason why I'm analyzing this is because in the affidavit in opposition they said that notwithstanding these provisions, the company still continues to be liable under the other provisions of the this award. But my respectful submission is this: if your Lordship looks into this,
is there anything else apart from this,
at least
which remains as a residuary after control not being taken against the company?
Kindly comes to page 206.
Show me the worst thing against you, Mr.
Yes, my lord. First of all, I'm showing your Lordship what are good things in my favor.
Good things, yes. Obviously, 2 to 6 suffer then.
And also, my lord, M.
Achha. Starts with 2.
In the event UpHealth Holding, the claimant elects to receive additional damages under subparagraph so and so, these persons will, the respond number 2 to 6 are not required to comply with the following order and paragraph. Therefore, my lord, these subparagraphs will not required to be complied with by them. That is with regard to the company. In other words, the moment, my lord, they fail to elect, my lord, to exercise their options prior to 30th September, then these subparagraphs, my lord, become OTOs. They will 2 to 6 are not required to comply with the following. And these are the subparagraphs which are concerned with the company. If your Lordship looks into subparagraph G, that your Lordship will please to find at page 202, permanent mandatory injunction with regard to the board of the respondent company. Then subparagraph H, this is, my lord, at page 204 with regard to the company. Then subparagraph R and S,
yes,
they are all, my lord, with regard to the company. Since, my lord, 30th September, if 30th September expires without their exercising option in terms of the paragraph which I have
Mr. Mithu, what is your submission R?
Yes.
Clause R, because local healthcare systems, along with the others, are to cooperate with UpHealth and cooperate on several counts.
Right.
So that remains. I mean,
this, my lord, the R also goes out. R is no longer required to be complied with in terms of M.
But R says the parties must give continuing effect to subparts C, E, and F.
No, but then again, kindly, my lord, come to page 206. In the event upheld elects to receive, then, my lord, 2 to 6 are not required to comply with the following orders.
Oh.
And, my lord, G,
very good.
H, R, S, they are not required to be complied with.
All right.
Once, my lord, they
Now they don't have any option apart from electing to receive additional damage.
once they receive the additional damage,
All
all
right.
these clauses go out.
All right.
So, my lord, therefore, my respectful submission is this: that choice was there. My lord, if I may just summarize my submission, choice for the claimant was twofold. Either, my lord, to take the company without all its assets.
If you offer.
Yes.
You never offered.
I never offered. So they will have to elect to take the company, truncated company, if I may use that expression.
And there is no provision in the award for a more basic option, twofold option, that if you don't offer, what happens? That is not provided.
Well, if I don't offer, then when 30th September comes,
then the other provisions come into force that if they don't take control.
Then kindly see that
language is wider then.
Yes. Well, 30th September is the D-Day, because by 30th September, without my making any offer, they will have to elect to take the company. Now, when they...
No, if you don't make an offer, they don't have that choice.
No, kindly see, my lord, kindly
which
come
clause?
to...
Yes.
The offer is confined, my lord, kindly see that 414, page 199. Offer an election is only with regard to truncated company. This is a very significant, and my lord, 415 is to secure the actual control of the entire company. That difference is made in the 414 and 415. The offer and election is not there in 415. 415 is with regard to all the assets. Kindly see the language here. If the offer has to be made if it is without or some or all of the assets. And so far as 415 is concerned, securing actual control of the company with all its assets. So if it is with all assets, then it is the choice of the claimant to come forward and secure that. If they do not do that by 30th September, they lose their right. If they want to take it, my lord, a truncated company, then an offer has to be made by me that, look, I cannot give you the entire company, I'm giving you company less 10.
Those assets, some assets.
And then, my lord, the election comes in. And if they elect to do so, then, my lord, they are entitled to take the company without any additional damage, because it is alternative additional damage. 414.
Yes.
And this has been reflected in the dispositive part of the award. And my lord, this. Okay. Well, in this connection, my lord, if your lordship takes this is a section 9. Their section 9. Paragraph. Well, let kindly come to this their own application in section 9, which was moved before your lordship. Their paragraph 11 at page 7.
Yes.
In view of the above, it is significant to point out that the award has now been confirmed by the judgment of the United States District Court of the Northern District of Illinois, Eastern Division, against all the respondents other than the respondent number 5, regarding whom the matter has been remanded back to the tribunal for further proceeding on the very limited factual reconsideration of whether he violated his duties at the EGM. The applicant thus is unequivocally entitled to primary damages, which the arbitral tribunal found to be the reasonable estimate of the loss suffered by the applicant for the period 2022 due to lack of control over respondent number 1 arising from the breaches of the respondent number 2 to 6. Further, upon the respondent number 2 to 6 failure to offer, kindly note this, actual control of the respondent number 1 to the applicant prior to 30th September 2024, and the applicant not having secured control of the respondent number 1 Honorable for 30th September 2024, the applicant is now entitled to additional damages amounting to so. So this is also their case.
With the leave of Mr. My senior, but don't get into this. My specific prayer is I've understood 30th September as cut off. In the EC it is there. So let him not labor on it and waste your lordship's time.
So you'll allow the application expunging local.
No, that I'll address your lordship. But this, he's absolutely right. We've understood 30th as the cutoff and we made prayers accordingly. So
That is the premise of Mr.
Yes,
Kes's case.
that's right. So I don't want him to unnecessarily. He's absolutely right on this. It's in our prayer only.
So, my lord, that is my prayer.
You rest your case there.
Lordship.
Very well, Mr. Let us hear. Yes.
Two things, Lord. So 30th, we've also understood the cutoff, which is why I didn't want him to unnecessarily. Here is an application where one party in a execution petition as a judgment debtor is seeking deletion of its name. So two things the lordship will just consider. One is that personally I'm aware that this court is a giant of civil law. I have not found, that's my assessment of the court.
To start on a wrong premise.
That's all right, Lord. I have not found a single provision under Order 21, or if I go back to a section 51, which is really the parent provision for execution, regarding addition or deletion of a party in an execution proceeding. It's not there. Orders come from the section 51 onwards pertain to execution. There is no such provision. So this concept of addition or deletion will come from therefore Order 1 Rule 10. If I'm not mistaken, lordship will correct me. I'm not very sure on this. So if I have to delete a party, I will have to come and tell the court that I am not a necessary or a proper party anymore. A party against whom there's a relief claimed in a proceeding is a necessary party. I have reliefs claimed against this petitioner, respond number 1, in the execution application, which survives even after 30th of September.
How?
They're independent. I have those reliefs because in my understanding, this award gives directions for making payment to A, B, C, and D. A, B, C, and D are directors and or shareholders of R1. R1 is a party to the arbitration agreement. R1 is a party to the arbitration award. R1 now is necessary to ensure the performance of the decree in execution against R2, R6. That's my part B. So I'll flank my argument into two parts. One is the court today on an application by this respondent can't modify the award, can interpret the award, but can't interpret the award in a way to nullify the award. Now, so first is, I will try and show to your lordship, which your lordship caught on while reading R, and Mr. Gupta and I were looking at each other, that even after 30th September, R survives in respect of local. If your lordship comes back to 206, actually comes back to R, Milo, that is page
206.
Come to 207 first.
Yes, 7 is there.
207 kindly comes to.
Must give continuing effect to subparts.
The parties must give continuing effect to subparts C, E, and F of section. The dispositive of the EA order is amended below pursuant to so and so. Sir, 107. 207. 207. Page number. So one is Local Healthcare Systems Limited.
Mr. Banerjee, if you don't have control of the company, then R becomes, academic.
No, I'll tell
So
you
where is the
why R
option?
remains.
All on unaudited financial statement. Why should they give it?
Comes back to R. I'll tell you, lordship, why.
Yes.
Local Healthcare Systems Private Limited. That's R1, then R2 to R6. Kindly now turns down to 2. Local will cooperate. So R1, again R2 to R6, individually, jointly cooperate so and so. Kindly look at 3. 3 is why they want to get out of the execution. Local healthcare systems, this is R1 who's made the application so and so, are jointly and individually ordered to refrain from taking any steps to access the funds in Local Healthcare Systems Private Limited the bank account at ICICI Bank, account number so and so, where on the basis of 15th August 2022 board resolution otherwise, making or causing to be made any changes to the authorized signatory that can access such bank account, and making or causing to be made any other changes to such bank account. Now, why does R1 come up today? Because R1 has also given an affidavit of asset. So your lordship has invoked that power under order 41 rule 11, I would think, for affidavit of asset to come up, 21, for affidavit of asset to come up. Local's affidavit of asset has about only the ICICI bank account has an excess of what? 50 crores. All the others have no money. Now, even now kindly comes back to M.
Yes.
S, F. S. Yes, yes. Kindly comes to S. Correct. Why R1 is necessary. S. Martin Beck, the CFO, and or Jeremy Livianu, Chief Legal Officer, and or such other person as may be designated by the Board of Directors of Upheld, which is me by board resolution, notified in writing to ICICI Bank by the CEO of Upheld, attaching a certified copy of the resolution of Board of Directors of Upheld, designating may jointly or severally be permitted to access and operate local healthcare bank account. So now comes back to M at 206. In the event Upheld, that's me, elects to receive the additional damages under subpara so and so, then disregards the name below, the respond number 2 to 6 are not required to comply with the following paragraphs. G, H, R, and S. One is not letter. So from R and S, one doesn't go. 2 to 6 is absolved. So now, by this application, they want your lordship to modify this decree and say, look, even if the decree says one will remain, you throw one out also. That is not permissible. Now, in tandem with those reliefs, I'm sorry, in tandem with those reliefs that are there in R and S, the rest, your lordship is right, I actually don't care. But R and S is crucial for my execution. Your lordship would have recalled, sitting in 36, I moved the matter against Mr. Thakkar, where 2 and 3 were colluding and sending monies out. The chunk is ICICI Bank. And RNS actually protects that amount. I have prayers against R1 in the execution in respect of RNS, in the execution application.
Mr. Banerjee, tell me this.
Yes.
Can you even, because actual control has not been taken, 30th September is over now. Now, can you touch, even respondent numbers 2 to 6, can they touch the accounts of local, which is a separate juristic entity, in order to meet the claims against them? Because 416 at page 199 says respondent numbers 2 to 6 to severally pay, not in the capacity of directors, in their personal capacity.
So because
it has to be made from their accounts, not locals account.
No, they will make good the money.
Yes,
So
but locals account cannot be touched.
Because this is a closely held company with 1 and 2 and husband wife. I mean, sorry, 2 and 3.
But 416 does not cast any liability on local to meet the payments which has been imposed on 2 to 6.
So primary damages, then additional damages.
Primary, additional, both now.
So
Yes.
money comes to me from them. How do I have that secured is by at least having this bank account which has the money.
Which is of a different juristic entity, Mr. If it was a personal account of these people, then we could have understood. Locals account has no nexus with respondent number 2 to 6 as personal account.
Locals account, the money which is there, whether it's of local or not, the award says that this account will stay injuncted. If they succeed as a point under 48, that for this reason the award is bad, they have a 40, they'll succeed on that. But at
No,
this
that's
stage,
a different thing. Then the entire award.
Which is what I'm saying. No. So that is what my submission is, that if they succeed on that, they succeed. But by this application,
can the executing court touch the account of local by virtue of 416?
Well, the executing court can enforce the decree
Against
for
whom?
making payment.
Personal assets of respondent numbers 2 to 6 at best, the worst.
That is why I can have an injunction against that bank account to secure that 50 crores.
Bank
That is
account
my
does not belong to them.
Maybe, but the award grants me that right. The moment there's a award which is, or let's say a decree, and I have that money secured, if in the execution I can show that please lift the corporate well, because that's permissible to me, and I'll be able to show that these are the persons in control, I can get that money. The law, your lordship is aware, the law gives me that right.
That would be a fresh adjudication, Mr. Banerjee.
Look, that will
Which is
be
not permissible in execution.
Look, what is actually,
then it could have been clarified in the award itself that yes, that can be realized from the account of local.
Well, that is how I see RNS. What they want your lordship to do is actually to interpret the decree, not just that, but to nullify the decree. I have the decree against RNS. There is no other way of reading it that the RNS survives against R1 even after 30th September. What is the legal effect of that? They have a 48, I have a 47 or a 49.
But that argument, Mr. Banerjee, is a double-edged sword because R1 might have been not mentioned in that that release from RS, etc. Because of the simple reason that after 30th September, that R and S are contemplating scenarios over and above this. If 30th September, that control is not done, not taken by you. If that is not taken, then R1 goes out of the picture. That might have been the premise of not even mentioning R1 in M.
No, this specifically provides, your lordship will see, M and all disregards. R, what is important?
Yes.
R, kindly have a look at 3 and S. It's specifically with regard to the bank account of, because that is where my money has gone in. And this is not a case, my lord, where it's a third party to the arbitration agreement or a third party to the award. A picture has been given to the court that an award has been passed against a third party. Glocal received the funds that I gave. And a party to the arbitration agreement, party to the award. I am entitled to seek reliefs against it. This is not a case where I'm seeking reliefs against a third party to the arbitration agreement and I have damages against his directors. And the directors are saying, look, you can't touch the company. The company, this ICICI account has received 100 and 200 crores from me. This is the company in respect of which the entire transaction has happened. The money has gone in. In fact, as I address your lordship, it is my authorized signatory which operates this bank account by virtue of a Section 9 order which is there passed in a pre-award Section 9, passed by this honorable court. Look, simpliciter by coming and saying the award doesn't survive against me.
So what could be the reason of releasing 226 if only addition, it boils down to additional damages? Suppose R3, what could be the reason of releasing 226 from that?
Because these
do you mean to interpret this by saying that ordered to refrain, they are no longer ordered to refrain from taking any steps then to access the fund? No. So they may access the funds. Do you mean to say that this is for the purpose of making the additional damages payments? We have to read that into this.
Yes, because to prevent Glocal R1 from letting any other person access except me.
No, the effect of M.
The effect of it is that they can't touch. So basically, what happens? They will not take my money out and give it to me. What
no, but they have been absolved from that.
That's right.
M says
the injunction is on R1.
In the event you elect to receive additional damages. Now today it's an additional damage scenario. There is no doubt on that. The primary damage or additional damage.
While I address your lordship, it becomes clear, and it kindly comes back to 3.
Yes. Then today 2 to 6 are absolved from that restraint order. 2 to 6 are absolved from that restraint order.
No, 2 and 6 are also there.
No, by virtue of M.
By virtue of M. So if I don't get actual control, I don't come into the company.
Today is an M scenario.
Yes, today's M. No, I'll tell you
M theory, membrane theory.
I'll tell you, lordship, the distinction.
Yes.
If I get actual control of the company,
yes,
100% shareholding is mine. My person is anyways there.
Now we forget that.
Let us forget that. So
yes.
Chapter comes where my money has gone into local bank account.
Yes.
Local's bank account should not allow A, B, and C to receive that money to pay off my damages.
No, but 2 to 6 can now operate those accounts.
But local can't allow him. If your lordship sees 3, local is ordered to refrain from taking any steps to access the fund in healthcare bank account ICICI Bank,
No,
whether
not
on
that,
the
not
basis
that.
of 15th
Local,
August 22 board resolution or otherwise. So the resolution was that changed the authorized signatory. So it forgives me, but Machit Dele Majbada is not allowed. Whichever way.
that's a better way of,
That's a better way.
that's a more senior's way of putting it.
more pure.
Purity.
Pure.
Well, my learned friend will talk about something to eat. I have reached that age, my lord, when I am to offer my oblation to
No. Not at all.
Look, the other day
Your fitness speaks otherwise.
Touch wood.
You,
You're coming down the
you are still on the
escalator.
treadmill regularly. We have come to know. That is,
No,
I
don't
take
want to
judicial
change
notice
it.
of that.
But we were coming down the escalator and senior Mr. Mitru was walking down it.
Straight.
Straight.
Ramrod straight.
And we were talking about it amongst ourselves.
Yes.
Touch wood. No, I really don't
Yes,
want
yes, don't. Touch
So-
the wood. I mean, well.
Sorry, I have to digress
No, no.
for a moment, my lord. I think my learned friend will permit me.
Yes.
My lord, at the moment, my lord, I only remember what Tagore has said. শ্রান্ত চরণে চলি পারে যাত্রা হয়েছে মোর সাঙ্গ সুর থেমে আসে বারে বারে ক্লান্তিতে আমি অবসাঙ্গ well I have reached that stage now.
I won't comment on that. Cannot. Should not. But you have to come back to local. So you say that local has not been absorbed.
Look, can I put it differently? If your lordship does not take me amiss.
Hmm.
Look, I am saying, and I place my case as high as that I don't need to really come and indicate why the decretal court thought that this decree should be passed.
No, we can only look into the award.
Decree as it stands.
On the face of it.
On the face
So
of it.
on the face of it, you say 3, by virtue of 3, local still is to refrain, I mean, is restrained from taking these steps,
I'm only saying
which is
that-
not absolved by virtue of
Yes.
M.
My cutoff date 30th, it doesn't matter. Post 30th, it remains. There are reliefs that I have claimed. There are reliefs that have been granted to me in the award. And this is a case where this company is a party to the arbitration agreement, is a party to the award. So there can't be a jurisdictional error. Because an executing court can go and
This will continue to operate. R3 will continue to operate as an injunction order against
till
local.
the money is paid to me.
Till the money is paid to.
Till the money is paid to
Very
me.
good.
Because that is necessary so that they don't access that and take my funds out and pay me.
All right.
This injunction order is there. So today, all that is there before your
So we can implement, the executing court also can implement this injunction order against local.
and that's a specific
And section 9 all the more so. I mean,
I'll show to your lordship the specific prayers I have.
show me that.
I'll show you lordship the specific prayers which are there. If your lordship looks at page 530,
A copy has been handed over.
EC prayer G onwards.
EC.
Volume 1 today.
Yes, EC টা ছিল। এখানে ছিল। হ্যাঁ, এখানে ছিল। এখানে, হ্যাঁ? এখানে tabular statement এখানে। Yes, which prayers?
Yes, G onwards, your lordship. Affidavit in support of the tabular statement. Kindly comes to page 2. Page 2. I'll show prayer G first. Because that is why I stopped my my senior here. In the event, page 2 is fine.
Yes, in the event.
G kindly see.
G.
In the event the petitioner does not secure control of the respond number 1 on or before 30th of September 2024. So this is my understanding also, cut off. So I don't want to argue something that's stupid. And then prime damages, kindly have a look at I.
I and J.
I and J and K. And most importantly, my lord,
Yes. So
L.
K is in terms of R. R,
K is-
R3 and S.
That's right. K is in terms of R3. L is also there. M. It's all prayers that are there. And if I go back to Order 1, Rule 10 principle, a party against whom relief is claimed is saying that please delete me, I want to go out at this date. Now, one additional fact, Manoj.
Yes.
I know the fact that the US court confirming or not confirming the award had weighed on this honorable court. So, in aid of that, the US court has now injuncted R1 from going out of the proceeding. That is, kindly have a look at my affidavit in opposition that I filed. Unshow object কেন does not liquid text এটা কি রকম করে এটা কোথায় আছে বলো তো page 48 of my affidavit in opposition.
I don't know. এখানে আজকে দিয়েছি
At 49.
Yes, yes, restraint.
Yes.
Local also.
Local also. This is dated 12th of November. 12th November 2020.
This is in the confirmation proceeding before the.
This is the confirmation proceeding before.
So this order still remains.
This order still remains. This order still remains. The award survives.
Yes, obviously.
And no, again, this
Otherwise we would be
after
wasting
30th
time.
of September.
Award survives, definitely.
And I have reliefs against them. Now, my lord, just to take it slightly higher, just to show to your lordship that we've also read up and studied and come.
Yes.
Nah, to judgment just high court judgment. If he was a non-party, this while we were looking up, if a third party to a decree can be added in execution, that there's a judgment of this honorable court that says a third party, because I was also doing some general reading, because if I am adding a party to the list for whose presence is effectively required or required for effective disposition of the case, then that person remains in the books.
Specific performance and other scenarios are there. Very.
That's right. That is this.
So you want to read the converse into this scenario. I mean, this is the opposite. They are wanting to go out. They were parties to the award.
That's right. So I'm saying even if they were third parties, I'm saying if your lordship
Third parties can be added.
If your lordship reads,
but on the same logic, Mr. Mitra would say that third parties can be added if they are necessary, if their presence is still necessary. By the same logic, if presence of one of the parties is not necessary, may be expunged under 1 Rule 10 principle, although not strictly available in execution case.
Yes, I am saying, but I really needn't go there.
Yes,
because here it is firstly clear. Secondly, he was a party to the arbitration proceeding and a party to the award.
Yes, yes.
So this is not a case where I'm trying to add. But even if he was, let us say the award was not, but I honestly let's not add. But this is what. Lord, we were carrying decisions that the court can't modify, executing court can't modify the decree, can't go into it. But my only thing
modify the award.
Modify the award of the decree.
Obviously, we cannot. Executing court cannot go behind it.
And my only thing that I want to address last, is that the executing court can say it's a nullity. But that's only on jurisdiction.
So that's a different proposition
different
altogether.
concept only.
That Mr. Mitra
Will
cannot
not
rely on
apply
at this stage. No,
that's all.
he's not saying that even.
These are my responses.
Very well.
Only I add this that just to what they have said in the affidavit in opposition, this application is with regard to interpretation of this. My learned friend very fairly, my lord, has agreed that he will not press that thing. Now, my lord, the only thing is this, your lordship will be pleased to see that once this subparagraph G to H have been deleted by under M at page 206, the 2 to 6 are not required to comply with the following orders paragraphs in this dispositive part. Well, I just asked this question to myself. Under this decree, under this award, after 30th September, against whom the decree remains? What is the decree? What is the award remains? Award is primary damage and additional damage. Nothing more, nothing less. After 30th September, this is the point that I am adverting to. After 30th September, nothing remains in this award excepting the payment of or enforcement of primary damage and additional damage. Then I ask this question to myself, against whom? Against, my lord, the response number 3 to 5 or 6. Insofar as the company is concerned, no decree remains, no award remains after 30th September.
Mr. Mitra, I'll make a pinpointed question to you. On the other aspects, you're right. Only on M read in conjunction with R3.
Yes.
S also to some extent. Now, M says in the present scenario, like when they claim for additional damages,
right?
Respondent numbers 2 to 6 are not required to comply. So 1 is not absolved, and R says local and 2 to 6, they will do this. They are restrained from making any changes, authorized signatory. And this coupled with because we cannot interpret the award or go behind the award at this stage.
Exactly.
So if the award says yes, still then, even in an additional damage scenario, this continues to apply to local.
Because to that my
then we have to keep you here.
But I am submitting to your lordship, to that my answer is this, that the award is against whom? X, Y, and Z, not against A.
No, it is still against you insofar as R3 is concerned.
Well,
by virtue of M.
Well, if there is no award against me, then how?
No, the award is now in the nature of injunction against you. You cannot make these changes in the authorized signatory, and this coupled with the other submission of Mr. Banerjee, we cannot be blind to that also, that the money went ultimately into this account, the company's account.
My lord, this completely militates against, my lord, what has been submitted before your lordship in the earlier proceeding. Kindly see, my lord, your lordship's order dated, this is exactly the point, 7th October 2024, your lordship's order. This is in a section 9 application.
7th October সেখানে ঢোকেনি উল্টো করতে সাজানো রয়েছে
At page 6, your lordship kindly sees.
Yes.
At page 6, the last paragraph.
Yes.
After hearing the parties, submissions have been made in the last paragraph at page 6. Insofar as the relief sought against Glocal are concerned, there is no question of grant of the same, since learned counsel for the respondents is justified in arguing that after September 30, 2024, even in terms of the award, no monetary component of the award can be implemented against Go.
No monetary component.
Yes.
We are not directing to pay any money.
Yeah.
But the restraint order, the injunction order from changing the signatory and other things.
Well, can that be done once?
But that award remains
Well,
against
your
you.
lordship-
R3 remains against you.
Your lordship sees, well, if I may read it again, in this particular paragraph, page 208, Glocal Healthcare Private Limited, etc., are ordered to refrain from taking any steps to access the funds of Glocal Healthcare Systems, that is the company, the bank account, or at ICICI Bank account number so and so, etc. This is, my lord, the preventing the parties concerned, that is, my lord, that respondents number 2 to 6 from having access. My lord, so far as my bank, the company's bank account is concerned, that is not to be accessed, my lord, from making any causing or made any changes to the authorized signatory or etc. etc. Now, my lord, my respectful submission is this: this will become a sort of, so to say, redundant and odious prayer, or rather award, after, my lord, this aim at page 206. When, my lord, they are not required to comply 226, if they are not required to comply with these provisions, that means, my lord, insofar as they are concerned, they are not prevented anymore from accessing the ICICI bank account. But I ask this question to myself: what does it mean? Look at the award. Award says they are not required to comply with the following orders and paragraphs. So, insofar as they are concerned, they are not required. So, if, my lord, the respondents numbers, the other respondents access to my account, the company's account in ICICI Bank, they are not prevented from doing so. So, if they can operate the bank account of the company, then the company cannot operate its bank account. Can it be so? The absurd situation will arise. Absolutely absurd situation. This particular provision is not applicable to the other respondents. So the other respondents will be entitled to operate.
I'm still searching for an explanation as to how this would operate. I mean, how this would be workable.
Well,
Because
I'm sorry
if the
to
respondent
say-
numbers 2 to 6 can operate your account and do the rest, change authorized signatory and all.
No. Sorry. ICICI bank account, they can hold other accounts, open other accounts. It is kind of a look at it.
ICICI, they have been absolved in respect of the ICICI
Yes,
account.
2 to 6. I am only looking at 1. 2 to
If
6
2
have
to
not.
6, now the remaining monetary component remains against 2 to 6.
But why?
If they can access the account and change the signatory, Mr. Banerjee.
When the award comes to be passed, I am the authorized signatory. The award holder.
No.
Even now, I am the authorized signatory, which is why the injunction.
Where is that
here.
said in the award?
That the order is there.
Which order?
S is also there, your lordship will see.
S is also similar like R.
No, S is notified in writing to ICICI Bank a copy of the resolution of upheld permitting to access and operate the ICICI Bank. Upheld.
This will not operate now.
No, it will not.
Against 2 to 6.
It will not operate against 2 to 6. So the injunction is against R1.
S is not even in against local.
Look, S.
The others will not be able to permit.
S allows me to be the authorized signatory of the bank account of Glocal, only ICICI Bank. And Glocal will not be able to remove me, and Glocal will not access ICICI. So by then, I am the ICICI bank account. Just a couple of order to that. Pre-award section 9, I was the authorized signatory to the ICICI bank account. So this ICICI bank account, they can't touch. The moment R1 gets out of this proceeding, I am going to be removed. And the affidavit of asset will disclose what is the amount they have in that bank account. They'll take that money out.
What was the role of respondent numbers 2 to 6 in S? Even without it, where is the scope of absolving them from S? I am trying to understand.
There was a board resolution. So what has happened is there was a board resolution. Your lordship will find reference to that earlier.
Now, this does not restrain in any manner 2 to 6.
Gives me the
Yes, but they have respondents 2 to 6 have been absolved in respect of S also.
Yes.
What is the scope of that?
That
in the first place, there was nothing in S against them.
So S is clearly something that authorizes me.
All right, very good. Yes. So as per S, you have that right, and
as per S, I have the right. As per R, R1 can't remove me. R1 will not access. Good or bad, this is there, and I am the bank account today. But why is it that this application?
Martin Beck and Jeremy Levenu, they are the your people.
My board, mine.
Your people.
These are my people, and they are there in the bank account today. Well, the question, the honey is here.
All right.
And if your lordship desires, I can show the order.
Which order? Justice Kapoor's order?
Yes.
Saying what?
That I am the authorized signatory to the bank account and I will have access.
But then I'll give Mr. Mitra a reply to this, a rejoinder to this.
But this was on.
No, even
yes,
then, this is
that's
being argued now.
No, Justice Kapoor order.
Which part? Last?
Paragraph 19. So far as Prayer D is concerned, it is submitted. There are nominee and authorized signatory of the petitioner having access to ICICI Bank of the respondent number 1 in view of the aforesaid, there can be no prejudice which would be caused to respondent if prayer D is allowed. So this coupled with
D in the section 9. This is
D in the section. Not this is pre-award section 9.
Achha, achha. What was D? What was D? As per DC, submission.
Look, R and S is primarily to secure this bank account.
No, what was D? Just tell us.
D, I'll just check. Just bears with me for some time. তোমাদের তো লিকুইড টেক্সটে থাকবে তখন তো ছিল সেকশন 9 প্রেজার সেট আউট না হ্যাঁ D.
Anyway, it was recorded that you are already having access.
Yes. And then whatever is there, RNS.
That was the premise of granting D, whatever D was. Good.
Sorry.
So I've heard you finally on this.
Yes.
Yes.
In this connection,
yes,
kindly take a note of paragraph 355. But I asked this question to myself, my lord.
Yes.
Kindly see so far as the application for execution is concerned, when that was made. That is pre-30th September.
Yes, yes.
So if that was made in the month of July, I think 1st of July 2024. So, my lord, at that particular point of time, all these arguments my learned friend has made was open for him to make. So, my lord, at that point of time, this question has not arisen. My learned friend says that under what provision of law can you be deleted? I say, my lord, your lordship's power is there, always there. And if not under anything else, under section 151, I am saying that look at the award. The award exempts me or exonerates me after 30th of September. It is quite possible that the arbitrators had not foreseen all these consequences, had given an award. We are bound by the terms of the award. Now, my lord, kindly see, in so far as the fund of the company is concerned, today, I mean, look at shorn of everything, all the technicalities. What is the award today after 30th September? 30th September, after 30th September, the award is primary damage and additional damage. Against whom? Against the defendant, respondent
2 to 6.
2 to 6. Not against respondent number 1. So, respondent number 2 to 6 will have to pay this amount of money if they succeed ultimately, and that will be in execution. Now, I am just asking this question to myself. The fund of the company is independent of the funds of the respondent number 2 to 8. Once you say that the respondent number 1 it goes out of the picture for all practical purposes, insofar as the award is concerned, then can it be said that in order to get the money which is payable by X, Y, and Z, I shall go and attach the bank account of the company? I submit to your lordship that cannot be done. And if your lordship looks into this particular award, it will otherwise make an absolute nonsense of it. Kindly come to again, my lord, page 208. The respondent numbers 2 to 8 are restrained from taking any steps to access the funds of Global Healthcare System Private Limited, bank account at so and so. This particular clause has been totally deleted insofar as respondent 2 to 8 is concerned. That means they are entitled to take access to the funds of the company.
If they can.
If they can. Now, and bank account of ICICI Bank, number so and so, or making any causing. And then again, insofar as the S is concerned, the Martin Beck and Jeremy Levian so and so may be designated by the board of directors of Apple so and so to attaching the certificate of the resolution so and so, jointly permitted to have access and operate the local. Well, how can this be done when after 30th September Global is going out of the picture altogether? No decree, no award is there against it. I say this, that there is no award against Global. Global has not been directed to do anything at all.
Then the executing court cannot sit in judgment over the award.
Well, yes, of course.
This clause is there as per the award.
The clause is
till today.
the clause is there.
And S is also, R3 is also there in respect of local.
My lord, I am submitting to your lordship that in so far as this
So you have to hold that the award is absurd by interpreting it.
Otherwise, what happens is this. On the one hand, you are saying that this particular party is exempted, is exonerated from the execution of the award insofar as the award is concerned. The money award is concerned. At the same time, you are saying that its bank account can be attached. Really, it comes to that. You are, on the one hand, the arbitrators are saying that this particular party, no, nothing can be done in respect of this particular party. They are exonerated from the scope of the award. But at the same time, you are saying that so insofar as the other respondents are concerned, their award can be executed against the fund of that company who has been exonerated. I submit to your lordship that is. Then, my lord, kindly come to paragraph 355 at page 172. 354 and 355. Page 171.
Yes.
Paragraph 352. Further, regarding the share account, it appears the funds in the same rightfully belong to the company. According to Mr. Beck, the funds in the share account were for the B share issued by the company, and then the questions and answers. I'm not troubling your lordship. Then kindly. Last question at page 172. So when you say earlier that you were concerned that the local board would take steps to change the signatory on that account, why were you concerned about that? Answer is because that was the money that should stay in the company. In the circumstances, then 355, it appears the funds in the share account were meant for the company and the funds were not owed to respondent numbers 2 to 6. The tribunal has no doubt that the respondent ought to be restrained from accessing the same. So my account is to be, they're restrained from this. Such relief is consistent with SPS framework, particularly clause 10.2, under which the claimant is to eventually own 100% company's shareholding. Given the breakdown of the relationship between the claimant and the respondent number 2 to 6, this clause would be rendered ineffectual if the respondents are permitted to access the funds of the share account. So the award is this, that the shareholders of the company respondent number 2 to 6 should not have the access to the account of the bank account of the company,
which has been removed now by virtue of M.
By virtue of M, my lord, I am submitting, if your lordship looks into the totality of the award, it is not removed and it remains, because otherwise it will lead to absurdity. For the debt of X, Y, and Z, A's account is to be, when, my lord, X has been specifically exonerated from this. And, my lord, the paragraph 355 is saying that the share account of this particular company is not to be touched by respondent number 2 to 8. On the one hand, you are saying so. And on the other hand, my learned friend is arguing that for the realization of the primary damage and the secondary damage, additional damage, which is, my lord, payable by the respondent numbers 2 to 6, the account of the respondent number 1 will be attached. My lord, I submit to your lordship, this cannot be the interpretation. Once I have been asked to go out, I go out. Well, these are my responses.
So G8 of 2024, I'll pass my orders next Friday. Okay. Hearing is concluded on G8 of 2024. Full stop. The matter shall be listed along with the other connected applications on December 20, 2024.
My lord, G8 one which I was making submissions, my lord, is it any point in me addressing one day, my lord, or 2 days before the vacation? The lordship keeps that not after.
Mr. Bachot, let all the applications appear, otherwise there will be a dissociation between the files. On the next date, if you just have somebody to submit this, and because they are put on notice also that.
I'll be there. But we've taken, I was making submissions. I told you a lot.
Basically, I'm fixing it on 20th to pass orders on 8th.
No, I understand. But I told you, Lordship, I will make some notes to shorten the matter. But we have progressed a lot.
Yes.
But on the next day, if your Lordship desire, although I don't want to bother yourself, your Lordship, with holiday reading, but the notes will be
no, by holiday in any way.
Next item is ours only. Next item. Will your lordship take?
You are the petitioner.
Yes, that man.
Dismissed.
But the next matter also,
But
my
this is not a formal expression of an adjudication. Yes, Mr. Vajra.
No, my lord, I'll treat that as formal. The next matter, my lord, I'm there, my lord, again. But if on the next day, my lord, 20th, my lord,
Yes,
serve
yes,
that
Mr.
after the
Bacha.
vacation.
I mean, I'll pass my orders on G8, whichever way I go, and then the other matters, if you want it to be after vacation, then we'll consider.
Lord, that's item numbers 12 to 16. I was talking about that. My 12 to 16.
The other matters.
Not the 12 item numbers 12 to 16.
These are not connected with this matter, local.
Not
Oh, acha,
connected.
acha, acha. 12 to 16.
Mr. Mitra.
My application.
12 to 16, should I adjourn it after the vacation? Mr. Mitra,
হবে না in any case. শেষ তো you all have to make a submission.
12 to 16 একটা order record করে দিন on the Mr. Bacha, you are appearing for whom? The petitioner?
সেই জন্যই বলছি।
কোথায় যেতে হবে বলুন না?
You are appearing for the petitioner in that?
No, Mlad. I'm for the responding. Mr. Mitro is for the petitioner in one, and there's someone else who's.
Mr. Bacha, let it appear on the next day.
Very,
We'll pass
no,
orders.
no difference. No difference.
Thank you.